Good afternoon, everybody, and thank you for joining us for this, the latest in Brick Court Chambers series of remote competition law seminars. You're all very welcome. Today's subject is merger control, a field of competition law which is clearly burgeoning, has occupied a great deal of CMA time and tribunal time over the last quarter year, and is likely to continue to wax as we move into what is likely to be a challenging economic environment. Over the course of the next hour, we will explore some of the latest developments in the field, as well as looking to the future and the post-Brexit merger control landscape. Addressing us this afternoon will be Aidan Robertson QC, who will consider recent challenges to final prohibition decisions, focusing on the Competition Appeal Tribunal's judgments in Tobii and the CMA given in January this year, and in JDSports and the CMA given last month. Sarah Ford QC, who will address the temporal element of relevant merger situations, focusing in particular on the Tribunal's judgment in Lebedev Holdings and the Secretary of State for Digital, Culture, Media and Sport, and the CMA's investigation in Hunter Douglas and 247 Home Furnishings. Tom Pascoe, who will address recent developments in the law on interim measures, focusing on the Facebook judgment given on the 13th of November, which was the same day as the tribunal gave its judgment in JDSports. And finally, Sarah Abram, who will address the UK merger control environment after Brexit, with particular emphasis on the nature of the changes to come and what the practical implications of those changes will be. If time allows within the hour available to us, we may be able to take questions. I've been asked to ask you to use the question box for that purpose. Let's see how we get on with time. And finally, on housekeeping, if I could ask everyone to mute your microphones and disable your cameras, I'm told that that will help the audio-visual experience. So the first speaker is Aidan Robertson QC. He will speak to us about Tobii and the CMA, in which he appeared as leading counsel for Tobii. This was an application under Section 120 of the Enterprise Act, challenging the CMA's Phase 2 final report on Tobii's completed acquisition of Smartbox. The tribunal's judgment, which runs to some 196 pages, represents an important authority on the standards applicable to CMA investigations. Aidan will also speak to us about the tribunal's very interesting judgment in JDSports, in which arguments focusing on the need for the CMA to incorporate the impact of the COVID-19 pandemic into its merger analysis ultimately won the day. Over to you, Aidan.
Thanks very much, David. Next slide, please. Next slide. So, as David has already mentioned, challenges to final prohibition decisions are brought by way of a judicial review application to the Competition Appeal Tribunal under Section 120 of the 2002 Enterprise Act. And in deciding such applications, the CAT doesn't apply a different intensity of review or a different standard of review to that which would apply in the administrative court. An attempt by myself and James Flynn to argue that it should was rejected by both the CAT and the Court of Appeal in B Sky B 10 years ago. It's quite an interesting contrast with the way in which the General Court has developed its approach to intensity and standard of review in the CK Telecoms judgment earlier this year. But those are the standards that we apply. Next slide, please. Now, very few final merger prohibition decisions have been successfully judicially reviewed. If you look back over the last 20 years or so, under the old regime, the Interbrew case saw a decision being quashed because of a failure to put an alternative potential remedy to the parties. But since the CAT's established, really the only case in which it's happened has been Stagecoach, in which the tribunal under Vivian Rose, as now Lady Justice Rose, took the view that the Commission had wrongly directed itself to establishing the counterfactual in that case. But since Stagecoach, there's been nothing until this year. Well, we do now have two cases in which there's been partial success for applicants, Tobii and JDSports. And like also Stagecoach and Interbrew, they're cases of completed acquisitions, so investigated only after the merger has been completed. Next slide, please. So starting off with Tobii. Tobii is a Swedish company. It acquired Smartbox, a British company, in October 2018. Prior to the acquisition, Tobii had relatively little presence in the UK. Both parties are suppliers of augmentative and assistive communication, AAC, solutions. These are fascinating devices which incorporate tablet computers to enable speech generation. So for people who are unable to speak, perhaps because they've had a stroke or they are suffer from mute autism, a number of other conditions, it enables them to tap out on a touchscreen symbols which generate speech. And for those people who suffer from conditions which means they can't tap on a screen, some of these devices incorporate Tobii's remarkable eye-tracking control systems, which allow them users to generate speech simply by looking at the tablet computer and controlling the cursor with their eyesight. It's really quite remarkable. We actually demonstrated it to the tribunal during the hearing. So the hearing took place in November last year. Judgment was handed down in January. It largely upheld the CMA's decision to prohibit the merger. And the CMA essentially prohibited it because it took the view this was a market in which there were only 4 players in the UK, and this was a 4-to-3 merger, and that was essentially the basis for their findings of a substantial lessening of competition, SLC. But we were successful on one ground, which I'll come to. The tribunal refused to remit the case back to the CMA for reconsideration on the ground on which we won. So we applied for permission to appeal that. The CAT refused it. We then put in an application for permission to the Court of Appeal to appeal. But in the meantime, Tobii was working on the divestment of Smartbox, and that in the end was completed in October. So the application for permission to withdraw, for permission to appeal, was withdrawn. Next slide, please. So we lost on 4 of 5 grounds of review. As David's already mentioned, it's a very lengthy judgment, and it was a pretty root and branch attack on the CMA's decision. I've listed there the grounds on which we've lost, but I'll just concentrate on the one on which we won. The tribunal agreed with us that the CMA had made findings on vertical foreclosure without any evidential foundation and on a theory which just didn't stack up, didn't withstand any proper scrutiny. The theory was that the combined entity would have an incentive to raise the price of Smartbox's flagship grid software. Now that software is available for download and use on a variety of devices. The CMA said, well, you can stick the price up for that, to which the answer was, why on earth would we want to do that? We'd lose sales, and more importantly, we'd lose our reputation. And you've got no evidence that we're going to do that. So it's an interesting finding, because it does show the tribunal willing to roll up its sleeves and engage with half-baked economic theory in the decision. I think in particular it really helped that this tribunal had as one of its members Derek Ridyard, who is one of the country's leading antitrust economists. Turning then to JDSports. Next slide, please. Now, this was an acquisition completed in the middle of 2019. JD Sports, most people will have heard of them, probably fewer people have heard of Footasylum. They're both retailers of fashion wear and sports casual wear. The JD Sports, large high street presence, Footasylum, a more recent entrant, so really only about a sixth of the size on the high street. Investigated after the purchase was completed, then JD and prohibited on the basis that they were close competitors on the high street, and that the merged entity would face relatively less competition from direct to consumer supplies of sportswear by brands, particularly Adidas and Nike, and also that Fraser Group, who I acted for at one point during this case, Fraser Group, better known to most people as Sports Direct, was a relatively less effective competitor due to its inability to get access to the main branded goods from the likes of Adidas and Nike. So CMA found substantial lessening of competition. JD Sports applied to the CAT, remote hearing in September, judgment middle of last month, quashing the CMA's decision, not on its principal merger assessment, but on the way in which the CMA, in the CAT's eyes, failed to properly investigate the impact of the COVID-19 pandemic on the market and its likely impact in the future. Now, the CMA has applied for permission to appeal, and this, I don't say this just out of loyalty to our fellow member of Chambers, Marie Dimitri, who's acting for the CMA. My guess is that it will get permission to appeal, and that appeal has got a good prospect of success, and I'll explain why I say that. Last slide, please. So the three grounds of review, as I said, the SLC assessment, the challenge to that was rejected. The assessment of constraint to the merged business from Fraser Group, Nike, Adidas, that was dismissed on a conventional competition analysis. But where JD Sports were successful is that they succeeded in persuading the tribunal that the CMA had not properly investigated the impact of COVID-19. Remember, the investigation started just as the impact of COVID began to be appreciated. The final prohibition decision was taken on the 6th of May this year. I think the statutory deadline for the report was the 11th of May. The CMA had written to retailers, suppliers like Nike and Adidas, and the parties in February, asking them for their views on the impact of COVID-19 on the competitive landscape. It received replies which the CMA regarded as really not providing any useful evidence. It was just too uncertain. So the CMA took the view that, well, insofar as there's an impact, it's going to be market-wide. We don't think we're going to get any more useful input from either the parties or suppliers or other retailers. So we're not going to revisit this issue before we deliver our final report. The Competition Appeal Tribunal, chaired by Peter Freeman QC, took the view that that was an irrational failure to investigate what it regarded as a key issue. The tribunal took the view that even though the statutory deadline was looming, the CMA could have written to suppliers, retailers in April and get an update from what they've previously been told back in February. The CMA's view on this is, I think that, well, that's actually only based on another 6 weeks worth of trading data. How much different a view are you going to get in April? And there's a lot of other stuff that has to be done before the inquiry is completed by its statutory deadline. So that's the reason for not doing this. Now, the tribunal, I think the CMA's view is the tribunal may disagree with that. The tribunal may have, if they'd been in charge of the inquiry, had done it differently. But that doesn't meet the threshold of showing that the decision not to pursue this was irrational. Remember, to show that something's irrational, you have to demonstrate that the decision is so unreasonable as to be a decision which no commission, properly instructed and taking account of all but only relevant considerations, could arrive at. And I think the CMA's view on that is, on the evidence, you just don't get there. But it's interesting. It's interesting in that it's the tribunal really grappling with the fact-finding process that the CMA undertook. Now, what do these cases show? Well, as David, I think, indicated in his introduction, these types of challenges, they have been quite rare up to now, but merger work in the CMA is going to increase exponentially from 2021, now that European mergers don't go off to Brussels. So I think these are important developments for what is going to be an increasing amount of merger work headed the CMA's way. What these cases demonstrate is that although it's difficult to challenge a final prohibition decision, it's not impossible, and there are also potential strategic advantages in doing so, not least in buying time to improve your prospects of divestment. Thank you very much, David.
Thank you very much, Aidan, for that very informative overview. Our next speaker is Sarah Ford. Sarah is in court today and so has pre-recorded her contribution. She will address us on Lebedev Holdings and the Secretary of State for Digital, Culture, Media and Sport, a rare media merger case arising under Part 3, Chapter 2 of the Enterprise Act. Sarah acted for the Lebedev interests in that case, and I acted for the Secretary of State. Sarah will also address the CMA's investigation in Hunter Douglas and 247 Home Furnishings. I'll pass over now to Paul Gray, who should be able to play the recording for us.
Good afternoon. The regime for merger control under the Enterprise Act 2002 is triggered by the creation of a relevant merger situation. The concept of a relevant merger situation is partly defined by reference to structural considerations. So two or more enterprises have ceased to be distinct enterprises, and either the turnover test is satisfied or the share of supply test has to be satisfied. But the concept also has a temporal element. If we look at the first slide, Section 23(1) of the Enterprise Act says that enterprises must have ceased to be distinct at a time or in circumstances falling within Section 24. And Section 23(9) tells you that the time you have to determine whether a relevant merger situation has been created is as at immediately before the time when the reference has been made. And that's an important provision which has been focused on in some of the case law. Section 24 sets out the actual time limits, and I put that on the second slide. And it contains two possibilities. The first is that two or more enterprises cease to be distinct within the last 4 months, and so a reference can be made within 4 months of the completion of a merger. The second possibility applies where notice of material facts about the merger has not been given, and this is a provision which extends time to investigate a merger until 4 months after material facts about the merger come to light. What's meant by giving notice of material facts is defined in subsection 2 on the third slide. Material facts can come to light in two ways. Either notice is given directly to the CMA, or material facts are made public. And the section also makes a distinction between anticipated and completed mergers. For completed mergers, once the material facts come to light, there's again a 4-month time limit for making a reference. So those are the relevant provisions. The first opportunity the Competition Appeal Tribunal had to consider those provisions was in the Lebedev case, which is on the next slide. Lebedev was about the acquisition of 30% stakes in Lebedev Holdings Limited, which is the parent company of the Evening Standard newspaper, and Independent Digital News and Media Limited, which is the publisher of the digital version of The Independent. The Secretary of State issued a public interest intervention notice, which enables them to intervene in cases involving specified public interest grounds. And the tribunal first considered whether the public interest intervention notice was issued in time. For that purpose, the time limits that we've looked at in section 24 applied, so the tribunal had to consider whether notice had been given of material facts to start the clock running. In that case, there had been various reports in newspapers of certain elements of the relevant transactions, and the question for the tribunal was whether what had been brought into the public domain through the press was sufficient to start time running. All the legislation really tells you is that there must be notice of material facts, and it doesn't say notice of all material facts, but equally, as the tribunal pointed out, the statute doesn't say any material facts or a material fact. So there was a task for the tribunal to decide what level of information needed to come into the public domain to start the clock running. What the tribunal said was that it didn't consider that there needed to be sufficient information to ascertain that the turnover test or the share of supply test is likely to be satisfied. It said it would be sufficient if the information showed that this was a serious possibility. And the test that it articulated was, save in exceptional circumstances, the information should include facts which provide a reasonable basis for considering that there is or may be a merger for the purposes of the Act. And in the particular circumstances of that case, the tribunal decided that none of the newspaper articles that were in the public domain contained some of the more detailed facts on the basis of which the Secretary of State had based their case for there being a relevant merger situation created. So the newspaper articles didn't start time running for the purposes of the relevant timing test. However, there was a second point, which was that the Secretary of State's own case was that a particular letter that had been sent to the CMA had provided sufficient information for time to begin to run. And that letter had been more than 4 months before the date on which the Secretary of State envisaged making a reference. So the applicant's case was that the Secretary of State was out of time to make a reference in any event, even though the public interest intervention notice might have been issued in time. So you'll recall section 23(9) tells us that the time you have to assess whether a relevant merger situation has been created is as at the time of the reference. And the applicant's case was that because more than 4 months had passed already, there was no longer a relevant merger situation. The temporal window for the Secretary of State to intervene had already closed. The Secretary of State's case was that there was no time limit for public interest interventions at all. And the answer to that question turned on some pretty dense statutory interpretation. And the tribunal clearly didn't particularly enjoy the process. It described the statutory provisions as labyrinthine, and it commented that it is unfortunate, to say the least, that the legislation concerning an important aspect of potentially significant commercial transactions should be so convoluted. But in the end, it concluded that the question of whether a relevant merger situation exists, including the 4-month temporal element, is to be determined at the time the reference is made. And that meant that the Secretary of State was out of time to intervene. Since then, the temporal element has come up in another merger case, that's Hunter Douglas and 24/7, which is on the next slide. This is a recent case in which the CMA was investigating the completed acquisition by Hunter Douglas of 24/7 Home Furnishings Limited. And the acquisition took place in 2 stages. First, in 2013, Hunter Douglas acquired convertible loan notes and certain rights in 24/7. And then in 2019, it acquired a controlling interest. And that gave rise to a question of whether the CMA had jurisdiction to investigate the 2013 transaction at all. The CMA's position was that it became aware of the material facts about the merger only in late 2019, and so it made the reference within the 4-month period. And it assessed whether the share of supply test was satisfied by reference to the parties' activities in 2019. And that was because, in accordance with section 23(9) of the Act, the provision that the tribunal applied in Lebedev, the CMA assesses whether a relevant merger situation has been created in relation to completed transactions as at the time of the reference. But that gave rise to a particular oddity on the facts of Hunter Douglas, because there was no dispute that at the time of the 2013 transaction, neither the turnover test nor the share of supply test was actually met. So had the CMA sought to investigate the merger at the time, back in 2013, it wouldn't have had jurisdiction. Sometime after the 2013 transaction, Hunter Douglas made another acquisition, and at that point the share of supply test became satisfied, but it wasn't satisfied at the time. So the effect of this as at provision in the legislation seems to be, on the CMA's case, to bring within the CMA's jurisdiction in 2019 something that would have been completely unobjectionable back in 2013. And the CMA's position on that was, well, that's the risk you take if you choose not to notify us of your transaction. Time doesn't begin to run until we know about it. That raises 2 issues. The first is, what is the correct construction of section 23(9) of the Act? In Lebedev, the tribunal seemed to think that the way it works was that at the point where the CMA is contemplating exercising its jurisdiction, that's the point at which it has to verify whether it's still in time to do so. And so it has to check whether the temporal element of the relevant merger situation is satisfied at that time. But there's no support in the Lebedev judgment for it having a wider function that means that you can assess whether the structural elements of a merger test, whether the turnover test or the share of supply test is satisfied by reference to the factual position at the time of the reference rather than the position when the merger occurred. And it's clear that that could lead to some very anomalous outcomes. The second point is section 23(2)A of the Enterprise Act 2002. And that provision states that the share of supply test is only met where the criteria are satisfied as a result of the enterprises ceasing to be distinct enterprises. So there's an additional causation requirement, and that causation requirement clearly wouldn't be satisfied if the share of supply test wasn't met back in 2013 when the transaction took place, and it was only satisfied sometime later due to an unrelated acquisition. In its provisional findings, the CMA backed down and it agreed that it didn't have jurisdiction in respect to the 2013 situation. But it was a bit cagey about why not. And what it said was that it had reached its conclusion taking account of the particular and unusual circumstances of this case, in particular, the very lengthy period which had elapsed since the 2013 transaction occurred and the lack of overlap between the parties at the time of the 2013 transaction. And that doesn't give much away in terms of why it chose to not exercise jurisdiction in 2013. And what this suggests to me is that the CMA is seeking to preserve the possibility of saying, in some other case where it's not so extreme, that section 23(9) does entitle it to assess mergers on the basis of facts at the time of the reference and not those at the time of the merger itself. So we shall see in due course whether that's what the CMA intends to do. Thank you very much.
Thank you very much, Sarah, albeit in your absence. Our next speaker is Tom Pascoe. Tom acted as junior counsel for Facebook in its recent Section 120 challenge to the CMA's refusal to grant derogations from an IEO it made in June this year relating to Facebook's completed merger with Giphy. IEOs are initial enforcement orders, which the CMA is empowered to make under Section 72 of the Enterprise Act to prevent preemptive action that might prejudice a merger reference on a precautionary basis. The jurisdiction to make these orders was amended by Section 30 of the Enterprise and Regulatory Reform Act of 2013, and Facebook is now a leading authority on the principles applicable to these orders. Over to you, Tom.
Thanks, David. As you foreshadowed, I'm going to speak about interim measures, which are temporary obligations that the CMA has the power to impose on merging parties at phase 1 and phase 2 of its investigations. And as you mentioned, interim measures were a key plank of the government's merger strategy when it reviewed the voluntary merger regime back in 2012 and 2013. It maintained the ability for merger parties to merge without CMA clearance. But the price of that is that they do so at the risk of a subsequent investigation and what the government saw as a more robust regime of interim measures. Could we go to the next slide, please, Paul? Now, the CMA's powers to impose interim measures at phase 1 of its investigation are contained in Section 72 of the Act, which doesn't give much away. As you can see from the text on the screen, the CMA can essentially impose a very wide range of restrictions, so long as it does so for the purpose of preventing preemptive action. And preemptive action is defined in that section as action which might prejudice the reference concerned or impede the taking of any action under this part which may be justified by the CMA's decisions on the reference, so basically remedies. Now, just to note, that's the power. There is a materially identical power in Section 81 for phase 2. And the key limitation in the statute is whether the CMA is acting for the purpose of preventing preemptive action. Could I have the next slide, please, Paul? Now, as I said, the statute itself doesn't give much away about what measures in practice the CMA may impose and when it should do so, other than supplying a definition of preemptive action. And the CMA has therefore issued interim measures guidance, which puts some flesh on the bone. That was most recently updated in June 2019 in light of what the CMA said was its experience of interim measures since 2014. And there are three particular aspects of that guidance I'd like to pick up on. The first relates to timing. Now, the guidance is very clear that where the CMA is investigating a completed merger, it is likely to impose an IEO very shortly after expressing an interest in the investigation, after sending the initial inquiry letter. By contrast, if the merger is an anticipated one, then for fairly self-evident reasons, interim measures are comparatively rare because obviously if the parties haven't yet merged, their capacity to do something which could preempt the CMA's investigation is just inherently reduced. The second point to pick up from the guidance is the scope of interim measures. Now, IEOs will generally be applied to both merger parties, so to both sides of the transaction, as well as those parties' UK parent companies. And this is an important addition where appropriate, overseas parent companies. And we'll see in a moment that that obviously has the potential to drastically increase the scope of interim obligations if they're applied to international parent companies of large multinational organizations. And the final point to take from the guidance is the form that interim measures will take. And the guidance is very clear that in a completed merger case, an IEO will almost always take the form of the CMA's standard template. If we could turn over, please, Paul. Now, I'm not going to go through the CMA's template. It's available online, but you can get a flavour from the left of the screen here of what it involves. It's essentially a 6-page document which lists a series of predefined obligations, and all that the CMA has to do is populate the names of the addressees into that document and send it to the parties. So it's a very expeditious procedure. And just to give you a flavour of the types of obligations that are imposed, there is, of course, the fundamental obligation that the parties shouldn't integrate any further. But there are also a series of additional obligations, such as not hiring or firing staff with managerial responsibility without the CMA's say-so, not changing the nature or description of your goods, and not making any changes to your organisational structure. And a key theme of the template is that it, of course, plays out extremely differently depending on the type of entity that is subject to it. If you're a relatively self-contained UK-based business, that's one thing. If you're a huge multinational corporation, these obligations obviously play out very differently. Can we have the next slide, please, Paul? Now, the template IEO is, of course, just that. It's a template, and it's an expeditious mechanism that allows the CMA to act very quickly when it decides to look at a merger. But the tribunal held in the Facebook case, and I don't think it was ever seriously disputed, that when this template is used, the focus must turn very quickly to the question of granting derogations from the template. And that is to ensure that any measures within the template that are not necessary or are disproportionate to the aim of preventing preemptive action are lopped off as soon as reasonably practicable to avoid unnecessary burdens on businesses. Now that, of course, is particularly pressing where the template is addressed to a large multinational parent company, and we've seen in two recent cases, the Amazon Deliveroo and PayPal iZettle cases, the CMA being willing to carve out from the template the international businesses of companies like Amazon and PayPal. But crucially, that didn't happen in Facebook, which segues nicely onto that case. Can we have the next slide, please, Paul? Now, for those who aren't aware of the background to the case, Facebook acquired a company called Giphy in May of this year. Giphy, for the uninitiated, operates a library of GIFs, which are the sort of small thumbnail pictures that you can put in your text messages and WhatsApps and Facebook messages that sort of move on a loop. So Facebook acquired that company in May, and at the beginning of June, the CMA imposed its template IEO not only on the direct merger parties, but also importantly on Facebook Inc., the US parent company, and all of Facebook's hundreds of global subsidiaries. Now, Facebook immediately the following day applied for a derogation, saying that the application of the IEO to its 50,000 global employees and its enormous network of subsidiaries across the world was unnecessary and disproportionate. And its main argument was that Facebook assets could never lawfully form part of a final remedy if the CMA decided that it was necessary to impose a remedy. And so there was no basis whatsoever for freezing them. By contrast, the CMA said it needed much more detailed information about the way that Facebook's business worked before deciding whether to grant the derogation. Next slide, please, Paul. Now, the tribunal's main finding in the case was that the CMA had acted rationally in asking for further information, and that was dispositive of the appeal. But I'm not going to focus on that point, not because we lost it, but because I think there are three interesting points of principle that can be taken from the judgment of wider application than the facts of this case. The first, and I think most important one, is what the tribunal said about the meaning of the words preemptive action. Facebook had argued that the CMA could only impose interim remedies with a view to protecting its ability to impose final merger remedies at the end of its investigation. The tribunal disagreed with that and held, as you can see from the text on the screen, that preemptive action doesn't just include conduct which might prejudice a final remedy, but also any action that has the potential to affect the competitive structure of the market during the CMA's investigation. So that finding may need to be unpacked on a case-by-case basis, but the import of what the tribunal appears to be saying is that the CMA can essentially freeze the merger parties' activities on the markets that they are active on, even if doing that is not necessary to preserve the CMA's ability to investigate the merger and impose a final remedy. So that is really the main innovation, so to speak, of the tribunal's judgment. If we could turn over, please, Paul. The second point is that it was common ground that the CMA has to act proportionately when imposing an interim measure. But the tribunal was much more opaque about the standard that applies where a party asks to be exempted from an interim measure, so requests a derogation, and the CMA refuses to decide that derogation on the basis that it needs more information. In some parts of its judgment, the tribunal seems to find that the standard was essentially very light touch rationality review, but it then muddies the waters at 148 of the judgment, where it says that domestic standard of rationality is flexible and can be adjusted to take into account proportionality. So that seems to leave the door open to an argument that the CMA cannot refuse to decide a derogation by burying the requesting party in very burdensome information requests. And thirdly and finally, it's really a non-point. The tribunal didn't decide Facebook's main point of principle that acquirer-side assets can't be frozen as part of an interim measure absent some extraordinary circumstance, because they could not lawfully form part of a final merger remedy. Facebook's argument was essentially that it could never lawfully be required to take some of its assets and put them into a divestiture pot in circumstances where the wholesale divestiture of Giphy remained an option. In other words, Facebook could never lawfully be required to sell more than it bought. And the tribunal didn't decide that point in light of its anterior finding that interim measures are not actually restricted to just preserving the CMA's remedial options, but actually go far further than that by allowing the CMA to freeze the competitive structure of the market. So I end just with the tribunal's conclusion at 161. As I said, it dismissed the appeal, but it did say that Facebook would appear to have good grounds for submitting that the IEO is unnecessarily wide and burdensome. And that, I think, leaves the door wide open to other companies in Facebook's position, arguing that the application of the CMA standard template to them is disproportionate and therefore potentially unlawful. Thanks very much.
Thank you very much for that overview, Tom. Facebook is certainly a very interesting and important authority for multiple reasons, including the degree of engagement and cooperation with the CMA expected of merging parties at the interim stage, and perhaps an interesting indication of how invasive IEOs can be is that although the maximum remedy the CMA can impose in respect of the completed merger is divestiture of the acquired enterprise, the CMA is nevertheless empowered at an early stage of the investigation to impose restrictions, which, as Thomas explained, can have the effect of largely paralysing the acquiring enterprise's business activities, not just here in the United Kingdom, but elsewhere also. Finally, today we have Sarah Abram, and Sarah will address us on a topic of huge interest to practitioners, namely the rules we will all have to apply and advise on in the post-transition landscape, including, no doubt, the relevance of the EU merger regulation after the 31st of December. Over to you, Sarah.
Thanks, David. It now feels like a sepia-tinted dream, but there was a time when it was impossible to imagine a more seismic shift in the competition law landscape than Brexit might be. That was the era, if you can cast your minds back, when our principal concern when we were catching the early Eurostar for a lunchtime meeting in Brussels was when our Irish passport might come through. Of course, now COVID has usurped Brexit as our primary national preoccupation, but it's Brexit that will have the longer lasting effect on UK merger control and litigation. The saga around the Amazon Deliveroo case shows that at least some of the changes which have been born of COVID will be short-lived in competition law terms. Brexit's different in nature from the coronavirus pandemic because it involves hard-edged institutional change. As we all know, the key point is that for mergers which are not formally notified to the Commission before the end of the year, the one-stop shop for EU merger control will no longer apply in the UK. And that means that prospective parties to mergers that would previously have been exempt from review in the UK because they have a community dimension will now also have to consider whether to engage with the CMA about the intended transaction. That requires particularly careful evaluation, in a sense, because of the non-mandatory nature of the UK's merger regime. On the one hand, there's no legal obligation to incur the costs and time of notifying in the UK. But of course, on the other hand, not notifying puts the parties to the merger, the anticipated merger, at risk that the CMA will later open an investigation and potentially require a completed merger to be unwound. That's, of course, a familiar dilemma to all of us from UK-only cases already, but it's particularly difficult to advise clients on these issues in large multinational mergers at present, because the way in which the CMA will in future work with the Commission and other regulators remains rather unclear. There are some good, promising recent examples of different national regulators working together, for instance, on remedies in the merger context. But there's no guidance on when the CMA might or might not consider this appropriate. We might all hope, for instance, to see a cooperation agreement between the CMA and the Commission, for example, on sharing of disclosure. But perhaps in reality, the Commission won't have much incentive to tie its hands in that way in a month or a year's time. It's clear that the CMA, as Aidan has already adverted to, will certainly see a substantial increase in workload as a result of falling outside the one-stop shop. Estimates of the likely increase in phase one merger reviews vary really widely, from between about 40% and 80%. It seems to me to be strongly possible that the increase in notifications will be most dramatic to begin with, and then may tail off to some extent as the new regime settles down and beds in. On the other hand, of course, as many of us will know, Andrew Tyree suggested in the past that the UK might move to a mandatory notification regime, at least for some particularly high-value mergers, to increase alignment with the timetable of merger reviews in other jurisdictions. That would require primary legislation, and there are obvious practical barriers to that, not least the capacity constraints in Parliament at present. But introducing mandatory notification for some cases would fit with the CMA's avowed ambition, which is to be a leading global regulator alongside those in the US, in Australia and in Japan. And to stretch a metaphor, of course, if you want to be taken seriously on the global stage, it's no use arriving only after the curtain has come down at the end of the play. Looking beyond the CMA's institutional role, I think we're likely to see shifts in 3 further areas as a result of Brexit. First, as I think that the examples already given by Aidan, Sarah and Tom have shown, we're already seeing a marked rise in interventionism on the part of the CMA. More and more mergers in the UK are either prohibited or abandoned by the parties in response to antitrust concerns. The CMA is also calling in mergers more often now. A good example of that, a striking example of that indeed, is the Sabre Fairlogics merger. That transaction was cleared by the courts in the US, but it's been blocked by the CMA in the UK. The question whether the CMA had jurisdiction at all is controversial because Fairlogics has no direct contracts for its services with UK customers. The CMA found that it had jurisdiction because Fairlogics has a technical agreement with BA as part of a contract with American Airlines. The CAT's judgment on the party's appeal is awaited. We can expect that trend to increased interventionism to continue, though, whatever the result of that particular case, and that will be stimulated by the CMA's revised draft still merger assessment guidelines. They show an unsurprising focus on digital sectors, and one of the ways they do that is by expressing interest in features that are particularly likely to arise in tech-driven markets. So, for example, in the draft guidelines, the CMA focuses on two-sided marketplaces, non-price competition, and markets which feature long lead times to achieve market entry. Second, an increase in merger litigation in the UK, as Aidan has mentioned, is bound to follow from the CMA's increased role and its increased tendency to intervene. Merger litigation in the EU is just not quick enough to be usable in fast-moving commercial contexts. As we all know, it's often only realistic to challenge a Commission decision if the decision raises wider sectoral concerns or may set an important or unhelpful precedent for the future. Just take, by way of example, the appeal to the General Court in the Hutchison-Telefonica merger case. The Commission prohibited the merger in 2016. The General Court gave judgment 4 years later. An appeal to the CJEU is still awaited. And the position in the UK is just radically different. In essence, the CAT in this jurisdiction will move as quickly as the situation demands. So in JDSports, the case went from the CMA's decision to the CAT's ruling in 6 months, and that included an extension of time because of COVID. In Tobii Smartbox, there were 5 months from the CMA's decision to the CAT's ruling. And that kind of timing makes it genuinely realistic to challenge a CMA decision. And if you add that to the CMA's increased interventionism, plus the inevitable areas of legal uncertainty and change after Brexit, it's clear that merger litigation is here to stay and is on the rise. And it's important to note that depending on the client's perspective, the prospect of effective merger litigation may represent an opportunity rather than a risk. So, for example, we mustn't forget the cases where a third-party competitor might want to challenge a clearance decision or a decision to accept behavioural rather than structural remedies. The third point of importance for the future is that further change is inexorably on its way. We don't have time to talk now in detail about the National Security and Investment Bill, which was introduced a couple of weeks ago. that's scope for a separate seminar on its own. But in a nutshell, the plan is to replace existing powers to review mergers on public interest grounds with a broader right of review of foreign investments. There won't be a minimum deal threshold, and the size of shareholding which can trigger an intervention will be much lower than under the Enterprise Act. Although the bill is identified as a national security measure, the sectors potentially covered are remarkably broad. For example, the government is consulting on including the transport sector or parts of it. So to pull the threads together, one of Shakespeare's less attractive characters said pompously that Britain is a world in itself. That wasn't true in the 1600s, and it's certainly not true today. In reality, Brexit, of course, underlines the interconnection between the UK's regulatory framework and those of other countries inside and outside Europe. And the government finds itself torn between that reality and the tendency to protectionism that's invited by measures like the National Security and Investment Bill. In another 5 years' time, my bet is that we'll be talking about how those two competing objectives have been reconciled in practice. Thanks very much, David. Back to you.
Thank you, Sarah, for that very timely and informative contribution. Astonishingly, that takes us to the end of our allotted hour for today's seminar, which means that we won't have time to field questions, which is a great shame given how much food for thought has been served to us by today's excellent speakers. I'm sure I speak for all of our listeners when I say that I found today's observations enormously enjoyable and informative. Thank you also to everyone who joined us for today's seminar, and I'm sure I speak for all of our speakers this time when I say that we hope to see you all again soon, preferably in the flesh, in the very near future. And in the meantime, thank you and happy holidays.